Hello everyone, welcome to Shorthand Battle. I am Divya and I am going to dictate you a legal passage of 500 words at the speed of 110 words per minute. So be ready for the dictation. 3, 2, 1 and go. Being aggrieved by the said award of the Labour Court, the first respondent herein preferred a writ petition before a learned single judge of the Guwahati High Court, who, after hearing the parties, came to the conclusion that the finding of the Labour Court that there was extortion of documents by the workmen concerned was contrary to the charge sheet, which did not contain such an allegation. It came to the conclusion that allegation of extortion was an afterthought. It also accepted the defense of the workmen that they entered the estate only to obtain treatment of the injured workman who was assaulted by the manager of the estate. It also held that the Labour Court did not apply its mind to the vital facts and circumstances of the case as alleged by the learned counsel for the workmen who appeared in the said writ petition. On that basis, the learned single judge came to the conclusion that the Labour Court did not appreciate the material on record properly and passed the order justifying the dismissal, which is disproportionate to the offence alleged. It also held that the workmen who were tried before the criminal court were honorably acquitted by the criminal court, and the departmental inquiry held by the management was faulty. On the said basis, it set aside the award and directed the management to reinstate the surviving workmen who did not have attained the age of superannuation with compensation of rupees 15,000 to each of them in lieu of back wages, and to pay compensation of rupees 30,000 to each of workers who have superannuated during the pendency of the proceedings, and to fix lump sum compensation in consultation with the petitioner, which shall be paid to the actual heir of the workman who expired without getting any benefit. It directed the management to pay the said compensation within 6 weeks from the receipt of its judgment. Shri K. R. Chaudhary, learned senior counsel, addressing the arguments on behalf of the appellant, contended that the Labour Court, having permitted the parties to adduce evidence in justification or otherwise of the finding of the domestic tribunal, and having recorded evidence in this regard, justly came to the conclusion that the management has established its case of misconduct against the workmen. He also contended that the finding in regard to the extortion of documents was not actually a new charge, but was in fact a part of the charge which referred to the wrongful confinement of the manager, and there being sufficient material before the Labour Court both in regard to the long and wrongful confinement of the manager and other officials of the state, as also in regard to the forceful extortion of a document agreeing to pay 20% bonus, the Labour Court was justified in coming to the conclusion that the workmen were also guilty of the said charge of extortion, and the original charge as framed by the domestic inquiry having clearly stated about the wrongful confinement of the manager of the estate. Stop.